Hello people, what's up? So we are recording here people the amendments for company law. This can be for old and new syllabus as well because there is no much difference between old and new here. There are no amendments people. If you have been a part of the previous class or if you have watched June 2023 amendments, then there is absolutely no amendments as such. Probably one or two are there, but absolutely I can say like zero. But I'll just randomly run you through the amendments. So just concentrate on that part. Okay, and people, one more thing, you can see that they have given you 46 pages and all. As I've told, for all the amendments, what they have given is a consolidated amendments, meaning what? They have covered the supplements from August till May 23rd. So 2 years amendments has been put. That means what people? I have already done December 21 amendment covered, June 22, December 22, June 23. 4 amendments together and fifth. Now whatever is there. So if you have watched till now or you have been the part of the class after that, then you have covered everything. So watch June 23 amendments, maximum everything is covered. If you have given an attempt previously, then everything is covered. But yes, just let us just run through. Yes, first one, extension period of company law committee. We have seen this in June 23 amendment itself. For ease of doing business, we had formed something called as company law committee. Now that time limit was extended because we wanted to take more and more benefit. The committee's time limit was extended. The tenure of the company law committee was time to time extended by government. This time also wide. MCA order dated September 5th, 2022. The tenure has been further extended for 1 year, that is until 16th September 2023. So the company law committee has been further extended. That's all. That's the amendment. Next one, sir. Small company definition has been amended. Now you will only know. You have been part of it. Now, small company is a company whose paid up capital does not exceed 4 crore, whose turnover does not exceed 40 crore. That's all. That's the amendment. Next one, sir. People, this is important, but not in company law. If you guys have already watched setting up of business entities amendments, in that strike off chapter, I have explained something called as CPACE. Please watch setting up of business entities, strike off chapter, this topic. Technically, it is not at all relevant here. More relevancy is in setting up of business entities. It is covered in setting up. Here, it is not relevant as such. But on YouTube only, setting up December 23 amendment is there. Watch in that. Is this clear? Okay. Next one, sir. This also I've done, people. If you remember, people, the land border sharing I've done. If at all India shares land border with any country, and if people from such country wants to invest into India, you have to take prior approval of central government. If you remember, this was already discussed. So where and all it will be applicable? If you want to invest into company, so PAS3, you need to give a declaration. If you want to invest into the company for the first time, INC9, declaration given by first subscribers and directors when you are incorporating the company, there also you have to give a declaration whether you are coming from a country which shares land border with India. If yes, you have to take prior approval of central government, only then you can invest. If not, you cannot invest. Next one, imagine if I have already invested. Now I want to transfer my investment to someone else, SH4. Now in all these cases, people, they have put one, what is that, extra condition in the form. They will ask you whether you are coming under a route which requires central government approval or not. They will say yes or no. You have to tick yes or no. If you tick yes in the form, you need to attach the approval given by the central government. Remember this entire topic, that is what is the amendment. It has been a part of it for such long time. Next one, where else it will come? DIR2. If a person wants to become a director of the company, again the same condition, he needs to give a declaration along with his consent form. DIR2 is a consent to become a director. In that he has to give whether he is coming from a country which requires prior approval of central government. That's all. These are the 4 places, and these were part of December 22 amendments. Yes, sir. Okay. Same thing. Now they are telling SH4. Everything will come. INC 9 will come. DIR2 will come. PS3 will also come. Next one, sir. The same thing, people. Land border. Sharing a land border. Same thing will be coming again and again. Yes, sir. See, in offer come application letter. PS4. This is for private placement. When you're going for private placement, offer come application letter, if you remember, people, in that also you have to mention, when you're investing, you are signing this application form and you're investing, you have to clearly mention, are you coming from a country which shares land border with India? Yes, sir. Done. Next one, sir. With regards to buyback, people, there was a clause already. Now, when you are submitting a return of buyback, people, we were submitting one certificate. What is that certificate? When you are filing with ROC, you are giving one certificate. The certificate that whatever the buyback rules are, the company has complied with all those rules. We used to give a certificate. This certificate, people, was signed by 2 directors of the company. If a company had a managing director, MD used to sign this certificate, meaning we have complied with all the rules of buyback. Now the word certificate is deleted. They have replaced it the word declaration. That's all is the amendment. Will they ask from exam point of view? Absolutely no. So what is amendment, sir? Earlier we used to file form SH11 return of buyback with ROC. Once the buyback is completed, that we have followed all the rules. That certificate was signed by 2 directors. Now the word certificate has been replaced by declaration. Done. That's the amendment. People, if you remember, register of members inspection, this was also covered. All the register of members and all, people, will be open for inspection. However, certain data or details will not be available when you are inspecting. What is that? Address of a person, email ID of a member, any unique identification number and PAN number. These things will not be available for your inspection. Personal details. Done. As I told you, there is no amendments at all. Yeah. Again, I told you also previously, if possible, watch the entire. I've uploaded also. I've uploaded in the month of May only. CSR only. I've made a video only. Watch that entire CSR video. It can be helpful from exam point of view. The entire chapter is available in the YouTube, and that's amended and updated. Watch that. It's very useful as well as helpful. Yeah. Sir, with regards to this DPT3 also, we had seen this. What is that, sir? Once the entire, you're filing the DPT3, people, whatever the details you're giving, you would have given the details of whatever are the deposit accepted and all those things. Those things, people, has to be audited. Whatever is the deposits you are filing, people, the form, those has to be signed or audited by an auditor. Such a returns has to be filed. That's what they are saying. That's all. So DPT3, whichever is filed, has to be signed or audited by an auditor. That's all. DPT4 was once there, now it is not there, so it is no longer required. Next one, sir. Charts also, people, we have done. If you remember, any company taking loan, secured loan, and they are taking a loan and they are creating a charge, all this has to be intimated to ROC in CHG1. However, a banking company borrows money from RBI, these transactions need not be intimated to ROC. Done. CHG1. This was also done, people. If you remember, this was a June 2022 amendment, people. So it's like 4 years old. This I've already covered to you in the class only. Basically, if at all you are claiming your shares from Investor Education Protection Fund, IEPF, certain formalities has been now compromised. You need not follow all this, like giving newspaper advertisement. You need not get a notary. You can, instead of getting notarized, you can get it self-certified. and you need not submit will or succession certificate if the value of the securities is up to 5 lakh rupees. So these are the certain exceptions given. Now that is what is being enjoyed here. The same thing they have again interpreted. If you look at it, the amendment, November 21. So we have covered. If you were part of the class after that, it is already covered to you in the class. So do not worry. Again, same thing. You need not worry all of this. It's done. See, CSR people, entire CSR, it's already done people. 2021. If you were part of the class 2022, these amendments were already done. So what I advise you to do, there's already a CSR chapter uploaded on the YouTube. Watch that chapter, that is more than sufficient. That will cover everything. Yes, so that's what is advisable. You can absolutely skip off. If you have already watched it, people, for your previous attempt, then you need not watch it also. Next one, sir, accounts audit people. Again, this is an old one, June 2022. If you were part of the class, we have covered this. You need not worry. Again, CSR. Okay, done. Transparency and disclosure. What is this, sir? This was also done, people. If you remember, it was there for June 2023. But still, I'll just tell you on the face of it because you're watching the video. Let us imagine, people, previously, if a company has done any public issue for further public offer, if they have raised any money from public, saying, let us take, for example, Zomato has raised money from public saying that the money will be used for delivery business and we have raised money. We have done an IPO, let us imagine. But the company is not using the money for delivery business. They want to use it for some hotel business. Now, if at all you wanted to deviate, whatever money you guys have raised, if you want to deviate, there were some procedures that were followed. Now, people, whatever the procedures were followed, they have now extended the same procedures for any money you guys have raised using QIP, meaning Qualified Institutional Placement. What is Qualified Institutional Placement? A private placement made to qualified institutional buyers, QIBs, like mutual funds, banks. If you have made a private placement to them and if you have raised any money, even for the money raised by them, if you want to change the object, they are telling you the process and procedure is same. You have to follow everything again. That's what they are saying. Read it. The listed entities are mandated to submit a quarterly statement of deviation or variation. Deviation or variation, quarterly statement to stock exchanges, indicating if they have deviated or varied in using the proceeds from the issue of the object stated for the issue. So every quarter I have to give a circular notice to the stock exchange. Have I deviated from whatever is the money I have stated in the object? Till the complete use of the funds of the proceeds. So whatever I have raised, completely it is over. Until then I have to file a quarterly statement. Earlier to the amendment, the statement has to be submitted only in the case of public issue, rights issue, preferential issue. Now they have also added the qualified institutional placement. So the same rule will apply to them also. Done. Next ones are OPC people. Very simple. Earlier people, we used to take consent form for a nominee. Whoever is a nominee, if he wants to become a nominee of OPC, the nominee of OPC name has to be written in the memorandum of association. You have to write it. There is this clause called 7th clause, that is your nominee clause. In the nominee clause, people, you used to write the nominee's name in the case of OPC. Now what they are telling, whatever is the consent form you have taken from the nominee, this has to be filed along with Spice Plus when you are incorporating OPC. So in the Spice Plus, whoever is a nominee, his name along with his consent has to be filed in the Spice Plus form for a OPC. That's the amendment. That's what is given here. Is clear, Ram? Done. Next one, sir. There is something called as material related party transaction. If you remember, in related party transaction, this is important for listed companies. From Companies Act point of view, it's nothing amendment. It is there in listed companies, so it is a SEBI amendment. But what does this mean, people? Let us imagine if a company is doing any transaction with a related party. We used to call it, let us imagine if a listed company, if the value of transaction, whether done it at once or if you're doing it in more than one transaction in a year, whether in one or in a series of transaction, if a company does any transaction with a related party, how much? If the transaction people exceeds 10 percentage of the annual consolidated turnover, meaning what, sir? Imagine my listed company's subsidiary company, my listed company's associate company. If I take all the companies together, how much is the turnover of all these companies? If all these companies turnover, let us imagine people was coming to somewhere around 1 lakh crore. And if the transaction, this listed company is entering with related party, whether in one time or all the transactions put together, if it is exceeding this annual consolidated turnover, 10 percentage of it, 1 lakh is complete, 100%, 10 percentage is how much? 10,000 crore. Imagine we are entering into a contract worth 11,000 crore with a related party. Now people, this was considered as material related party transaction. What if the company enters into a contract only worth 9,000 crore? It is within 10 percentage. So this was not considered as material related party transaction. Because it is not a material related party transaction, they were not scrutinizing this transaction with such a rigorous or such serious note. But if you look at the amount, it is still a big amount, 9,000 crore. So what did they add? They added a value. Now, if a company enters into a contract with a related party transaction, and if the value of the transaction people is 1,000 crore or 10 percentage of the listed entity, so if at all the value you are entering people is more than 1,000 crore or more than 10 percentage of the annual consolidated turnover, then it will be considered as material related party transaction. So now because this is more than 1,000 crore, this will be considered as material related. It is 1,000 or 10%, whichever is lower. So in our case, this is coming to 9,000 crore. 1,000 crore or 9,000 crore, whichever is lower. So if any transaction exceeds 1,000 crore, you have to consider this as a material related party transaction. Now this needs whatever are the approvals, whatever are the scrutinizations, you have to follow everything. Now this definition is considered as an amendment. This definition is not at all given to you. For you to understand it better, I've just given this for your information. Is clear now? All of you, the amendment is this also is not given to you. I've just put this for your information. That's all. That's the amendment. SH11 buyback, which we already discussed. What is this? Okay, this is, we have already seen this people, section 403. What is that? In certain sections, people, they will clearly say, let us imagine MGT 14 has to be filed with registrar within 30 days of special resolution. What if I do not file within 30 days? They say, people, the law has given you certain time. What is that? If you do not file any form within 30 days, they can collect you 100 rupees per day, and they will allow you to file the form even after the due date. So if you are filing it on 31st day, whatever is the normal fees plus per day 100 rupees, second day 200. Like that, people, the company can collect, the ROC can collect the fees, additional fees from you, and still can accept the forms from you. It is still allowed. Earlier they said you have to file within this time. Now they are telling you we can accept the form with the additional fees of 100 rupees per day. They will still allow you to file the forms. The fees can be different for different class of companies. Meaning if you are a small company, the fees can be different. OPC fees can be different. Or if you're a big company, the fees can be different. So different amounts may be prescribed for different class of companies. And it shall not be less than 100 rupees per day. That's what they will collect. Yes, sir. Sir, what if we filed one form late? Second form, third form. What if we are repeating? Whatever is 100 rupees per day, they can extend that to twice the amount. Meaning, people, it can go up to 200 rupees per day also. Shall not be lesser than twice the additional fees if you repeat the mistake. Clear? That's all. That's the amendment. That's all. These were part of the. It is already covering June 23. Yes, Shyam. Now this is the recent amendment. Now what is this, sir? This is people there in your fast track merger 233. In 233, what used to happen, people? You will already come with a consolidated plan. That plan will be filed with, if you remember, official liquidator, and it will also be given to an ROC. If you remember, we will see that. Okay, if you remember, we used to give the plan to official liquidator and ROC, and we would have given the plan to central government. You would have seen this, the fast track merger. If these people have any problem, they have to file their objection to central government. If they file, central government will conduct a hearing. If no, central government will give an approval. If at all official liquidator and central government file an objection, if central government is also of the opinion, yes, it is not in the public interest, creditors' interest as being tested and all. If you remember, central government will give the application and tell you to go under the normal method. That is, they will tell you to go under the tribunal's route. Now, people, they have added two things. One is timeline. Next thing is, people, they have added something called as deemed approval. What is it? See. As per the amendment, no objection or suggestion is received within a period of 30 days. Official liquidator and receiver, they did not file any objection within 30 days. Then, and the central government is of the opinion that the scheme is in public interest. So they also did not file objection. CG is also of the opinion it in the public interest. It may within a period of 15 days after the expiry of 30 days issue a confirmation. So 30 days over, they did not reply. Within 15 days, CG will give you a confirmation of the merger. So 30 days they did not give an objection. 15 days time, CG will give you an approval. Sir, what if within 15 days CG does not give an approval? However, if central government not issue the confirmation order within a period of 60 days of receipt of the scheme, it shall be deemed that it has no objection. Meaning what, sir? These people also did not file an objection, and it's been 60 days since we filed the merger application with central government and official liquidator and ROC. Within 60 days also CG does not pass any order, it will be considered as a deemed approval. This is a new provision, deemed approval. Next one, sir, where further objections and suggestions are received within a 30 days. So imagine official liquidator and ROC, they have filed objection within 30 days. Then, sir, the CG feels that such objections or suggestions are not sustainable. He feels whatever they have given is bullshit. It's not at all valid. Then it may, within a period of 30 days after the expiry of 30 days, as referred above, issue confirmation. Meaning, sir, we have given 30 days for them to respond. They have responded. Now, within 30 days, CG may pass an approval. Sir, what if within 30 days these people say, we have an objection, and CG also feels, yes, what they are objecting is right. CG will tell you to go under tribunal's route. This will be told within 60 days. See, the CG of his opinion that the scheme is not in the public interest. So official liquidator has also said it is not in the public interest. CG is also of the opinion it is not in the public interest. Then it may within 60 days of receipt of the scheme file an application before the tribunal. Within 60 days of receipt of the scheme, I will say go under tribunal, don't come under my route. So what is added? Timeline. Next thing that is added is deemed approval. That's all. That's the amendment. According to me, this is the only amendment. Yes, sir. Next one we will INC 9. I have already told you land border. Next one we will. Okay, this one there is something called as bonus share. Earlier, people, whenever you used to do bonus issue, In PAS3, whatever is the resolution you passed in the meeting, we used to file it as an attachment whenever you do a bonus issue. Now the amendment says, people, you need not file this attachment. What attachment? Whatever is the resolution you passed in the meeting, the copy of the resolution need not be filed in the PAS3 when you are doing a bonus issue. That's the amendment. Done. CPAS people, please watch setting up a business entities video. Sir, again people, the same thing, watch the setting up of business video. It is connected this also. Directors people, DIR2, land border. This is already covered people in June 23 attempt. If you remember, the independent director provision. Whenever you want to reappoint an independent director, you need to pass a special resolution. What if we did not get a special resolution, but we got an ordinary resolution? When we want to reappoint an independent director, imagine we did not get a special resolution, we got an ordinary resolution. Okay, in ordinary resolution also, the public shareholders who voted for the resolution are more than who voted against the resolution. This is in the public sector category, public shareholders category. Then such independent director can be reappointed. I repeat, ideally to reappoint an independent director, you need to pass a special resolution. Imagine you were not able to pass a special resolution. Then at least were you able to get an ordinary resolution, meaning were you able to get a vote more than the number of votes against, were you able to get that? Yes. Now check the public shareholder category. If public shareholders who voted for the resolution is more than the people who voted against the resolution, if that is the case, then yes, people, you can reappoint the independent director. That's again an old one only, not a new one. This is also an old one. What is that? In virtual meeting chapter, certain things cannot be discussed by a virtual meeting. There was something called as Rule 4. The Rule 4 has been omitted, if you remember. Meaning now you can discuss the prospectus, financial statements, and approval of this financial statements by audit committee. All these people can be discussed in the virtual meeting. Earlier it was not possible. Now all this can be discussed in the virtual meeting. That Rule 4 which said you cannot discuss all this now has been removed. So you can discuss all this even now till now in the virtual meeting. You need not conduct a physical meeting for this. What were they? Discussing financial statements, board's report, prospectus, the same thing. All these for audit committee and approval of merger, demerger, amalgamation and all of that. That's all people, nothing else people. That's all I said. There is no much amendments people. Just watch this. Just try to watch this CSR thing and go more than sufficient. That's it people. Wish you guys all the best. Thank you so much. See you. Bye-bye.